Women are often portrayed as composed and collected, especially in formal settings like courtrooms.
10 days. Ms. Coulter, you're disrupting this proceeding.
I promise you, I'm not trying to be like that.
Yeah,
But it's black and right. It's right there.
However, there have been numerous cases where women have defied this stereotype, showcasing craziest attitudes in courtroom. Starting with a case of a woman who attacks her own lawyer. In Green Bay, Wisconsin, 25-year-old Taylor Shabus faced a hearing after being charged with first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. According to police reports, a year earlier, Shabus had been smoking meth with her lover, 24-year-old Shad Therian. During an intimate encounter, Shabus allegedly snapped, strangling Shad to death with a chain. She then reportedly sexually abused and dismembered his body in the basement of Shad's mother's house. Shad's mother discovered the gruesome scene, finding her son's head in a bucket when she awoke and went downstairs. Shabus had fled, but was later found by police at her home with what appeared to be Shad's blood on her clothes. Shabus pleaded not guilty by reason of mental defect and appeared at a competency hearing alongside her attorney, Quinn Jolly. Jolly requested a delay for further evaluation of Shabus' mental state, which Judge Thomas Walsh granted. This decision unexpectedly provoked a violent reaction from Shabus. Shabus lunged at Jolly, swinging wildly. A deputy quickly intervened, wrestling Shabus to the ground while calling for backup. Despite their efforts, Shabus continued to resist, kicking and struggling. The courtroom was cleared as deputies subdued and escorted her to a holding cell.
You went off on your attorney, Taylor. You went crazy on your attorney.
You can't do that here.
You okay?
Yeah.
Okay, can you get your shoes on?
Deputies removed the defendant from the courtroom and escorted her to a holding cell.
So she...
After a short recess, the hearing reconvened. Jolly, unharmed from the attack, requested to withdraw from the case. 2 weeks later, at another hearing where Shabus was closely guarded by 2 deputies, the judge granted Jolly's motion, and a new attorney from the State Public Defender's Office was assigned to her. Shabus was not charged for the courtroom assault on Jolly. Subsequently, Shabus underwent a psychiatric evaluation and was found competent to stand trial. This determination allowed the legal proceedings to move forward, with Shabus facing serious charges stemming from the horrific events in Shad Therian's basement.
At this point, I'm going to put a motion in to withdraw from this matter.
2 weeks later, at a hearing where Shabus was escorted by 2 deputies,
State of Wisconsin versus Taylor Shabus.
The judge granted Jolly's motion request, and Shabus was assigned a new attorney from the State Public Defender's Office. She was not charged for the attack on Jolly.
If you thought that was the bad, this is because you didn't know about Stevie Dawn Coulter, who was told by her judge to be quiet and thrown her to the jail. In Hillsboro, Ohio, 27-year-old Stevie Dawn Coulter appeared for a pretrial hearing facing a 5th-degree harassment charge, a felony. Her legal troubles began 5 months earlier when officers observed her stumbling in public. Coulter admitted to being under the influence of methamphetamine and, upon attempting to leave, was arrested for obstructing justice and resisting arrest, both misdemeanors. While in custody, she escalated the situation by spitting at and grabbing the hair of deputies, resulting in the felony harassment charge. Despite being released on her own recognizance, she was placed under pretrial supervision, including mandatory drug testing. On the day of the hearing, Coulter intended to plead guilty, which could result in court-ordered drug counseling and potentially no jail time. She was represented by defense attorney Dennis Kerr, with Judge Rocky Koss presiding. The case was formally known as the State of Ohio versus Stevie Dawn Coulter. The proceedings took an unexpected turn when Judge Koss inquired if Coulter was all right, as she appeared to be struggling. Coulter responded that she had a severe headache, among other issues.
State of Ohio versus Stevie Dawn Coulter. Are you Stevie Dawn Coulter? Pardon me?
Right away, there seems to be something slightly off with the defendant.
Are you all right, Miss Coulter? I can't hear you. You have a really bad headache? Anything else wrong with you? Well, we'll go ahead and have this pre-trial, but a couple things I want to talk about.
The judge referenced a probation report indicating that Coulter had tested positive for gabapentin, marijuana, methamphetamine, and amphetamine. Coulter then attempted to highlight what she believed was a discrepancy in her arrest report. Judge Koss, however, insisted that this was not relevant to the current proceedings and instructed her to remain silent. Coulter continued to interrupt, prompting Judge Koss to warn her repeatedly to be quiet. Her persistent disruptions led the judge to hold her in contempt of court, sentencing her to 10 days in jail for her behavior during the hearing. As Coulter was being taken into custody, she delivered a final remark indicative of her ongoing defiance. Following her contempt sentence, Coulter was ordered to report to probation due to her multiple failed drug tests. However, she failed to comply, resulting in another arrest warrant and subsequent arrest. 6 days later, court records indicated that Coulter was ordered to undergo 6 months of psychiatric treatment to evaluate her competency for trial. Her legal proceedings remain ongoing as she awaits further court actions.
I have a report from the probation department that she's been testing positive for gabapentin, marijuana, methamphetamine, amphetamine.
I just have a question. Does it even test for gabapentin on a 10-panel drug
What's that now?
Does it test for gabapentin on a 10-panel drug test?
Okay.
I mean, I'm a very intelligent person, and I know a lot, and I just look stuff up. And in this statement from the police, from this one, it says, then I identified female Stevie Coulter, not Stevie Coulter identified herself. So he arrested me based off of...
Okay, well, that's not what we're here about here today, Miss Coulter. It's clear that you're not in a situation...
But they lied also, though, Judge.
You don't interrupt me, Miss
Pulling her
Coulter.
hair and everything. I was denied access to the videos.
Miss Coulter, be quiet.
Be wrong.
Be quiet. Don't speak.
Because they lied.
Be quiet, I said. I'm not lying. I said be quiet. You understand me?
It lied.
All right, I'm holding you in contempt, and you're going to be sentenced to jail for 10 days. Miss Coulter, you're disrupting this
I promise
proceeding.
you, I'm not trying to be like that.
Yeah,
But it's in
yes, you
black
are.
and white. It's right there.
All right.
I highlighted it. Then I identified within the first 3 lines.
I don't even know what you're talking about because it has nothing to do with what we're here for
The police
today.
officer that arrested me, it was wrongful arrest, and then I had 5 cops on me.
All right, you have an
I
attorney.
had 5 cops on me.
Miss Coulter, you have an attorney.
I wasn't even being I didn't even touch that girl. It was my only form of
Take her into
defense.
custody. Put a cuff on her.
I don't care if
Sure.
it's wrong. You're going to do trial. I want to do trial. I hate every person in this.
However, this next case is more shocking than the others. In the Oakland County Circuit Court near Detroit, Michigan, Judge Martha Anderson presided over a contentious case involving attorney Paul Nicoletti and his former client, Karen Stevens. The courtroom drama stemmed from an ongoing feud between Nicoletti and Stevens, with Stevens challenging a personal protection order, PPO, Nicoletti sought against her over stalking allegations. Stevens appeared in court seeking sanctions against Nicoletti, claiming that his PPO petition was frivolous and vexatious. She vehemently denied stalking and argued that the PPO was based on nonsense. Judge Anderson clarified that the PPO had not even been issued and questioned Stevens' basis for seeking sanctions when the PPO was not served.
May it please the court, Your Honor. Paul Nicoletti appearing on behalf of...
Good afternoon, Judge Karen Stevens and Coulter for my motion for sanctions against Mr. Nicoletti for this vexatious and frivolous PPO. My motion for sanctions against Mr. Nicoletti for this vexatious and frivolous PPO.
I'm sorry, on his what?
I have a motion for sanctions against...
I know that. And the purpose of the sanctions are based on what?
It was a frivolous and vexatious PPO based on nonsense. I am not stalking Mr. Nicoletti.
I haven't signed a PPO.
Stevens insisted on her constitutional right to be heard, but Judge Anderson interrupted, stating that Stevens' motion was wasting the court's time. Judge Anderson denied Stevens' request for sanctions and, in turn, fined her $500 for filing a frivolous motion. Stevens reacted angrily, accusing the judge of bias. Judge Anderson warned Stevens to exit the courtroom and pay the fine or face contempt charges. The case took another turn due to a clerical error 4 months later. Stevens returned to Judge Anderson's courtroom because only $5 of the $500 fine had been charged to her credit card. When the clerk's office tried to correct the mistake, Stevens objected, prompting a new hearing.
His petition for a PPO, let me...
Okay, were you served?
No, I wasn't, but may I...
No, you may not. How can you ask to sanction someone when you haven't even been served?
That's the point.
Stevens, do not interrupt me when I'm speaking, ma'am.
I have a constitutional right to be heard.
On what basis? There is no case before me, ma'am, other than the fact that you filed this frivolous motion, taking up this court's time for no good reason other than your own personal vendetta against this man. I did not issue a PPO. And here you are taking up my time so that you want me to chastise him and make him pay money? No, ma'am. Your relief is denied, and in addition to that, I am sanctioning you with costs of $500.
Thank you, Your Honor.
I knew it was fixed.
I beg your pardon?
I knew it was fixed.
Miss Stevens, I highly suggest that you just exit my courtroom and go pay the sanctions before I find you in contempt.
Judge Anderson reminded Stevens of the unpaid $495 balance and directed her to pay it immediately. Stevens argued that the show cause order was improperly served and sought to revisit the original protection order issue. Judge Anderson, however, focused solely on the unpaid fine. Stevens reluctantly agreed to pay with her credit card, but continued to challenge the sanctions and demanded to know the legal basis for the fine. Judge Anderson instructed Stevens to comply and reiterated that no further court orders would be issued. Despite her objections, Stevens was ordered to pay the fine and ultimately lost her battle against both the judge and Nicoletti. In addition to the court fine, Stevens was also required to cover Nicoletti's attorney fees.
Good morning. May it please the court, Karen Stevens?
Ms. Stevens, the last time you appeared in court, the court ordered that you pay $500 in costs. The clerk's office made a mistake with respect to your credit card, and only $5 was assessed as opposed to the $500. When the clerk's office attempted to correct the mistake they made, you basically objected to your credit card company, and that brings you here today. Do you have the $495 that this is the balance owed?
I have my credit card, but I did file an objection and an answer to this order to show cause that wasn't properly served. Didn't have an affidavit of merit.
Ms. Stevens, do you have $495 with which to pay today?
I just said I have my credit card. I do not have cash.
Very well then, Ms. Stevens. You may go down to the clerk's office, pay $495 forthwith to take care of the $500 that this court assessed you the last time you were here.
I'm entitled to know what statutes or court rules you rely on to sanction me in the first place. That's part of due process.
Ms. Stevens, do you wish to comply with my request, or do you wish me to find you?
Is it a court order? I need a court order.
Ms. Stevens, my clerk will call down to the clerk's office and let them know you are coming.
There will be no court orders, what you're saying?
Ms. Stevens, please do as I've directed you to do. Thank you.
But the craziest moments of woman doesn't end here. In the Broward County Bond Court in Fort Lauderdale, Florida, 80-year-old Dolores Shinus appeared before Judge John Hurley. Shinus had been jailed for resisting arrest after violating a restraining order filed by her ex-husband, Abraham Arthur Shinus, from whom she had been divorced for 31 years. Dolores began by explaining her situation, emphasizing that despite their long separation, she had not bothered her ex-husband. She revealed that they both resided in the same apartment complex, which Abraham paid for entirely. Shinus argued that his financial contribution led him to believe he could control her movements. Judge Hurley clarified that his primary concern was to keep her away from her ex-husband to ensure his safety. Dolores insisted she had no intention of bothering him.
Go ahead, ma'am.
Mr. Shanus, Abraham Arthur Shanus, and I have been legally divorced for 31 years,
okay,
and I have the papers to prove it. We both resided at 20 Bend, and he paid for the apartment entirely. His assumption is because he paid for the apartment, he's entitled to do as he pleases.
I can't get in the middle of who owns the apartment.
I know, that's not the point. The point I'm telling you.
I need to keep you away from him, all right?
I haven't bothered him for 31 years. Why would I bother him now?
Deciding on a lenient approach, Judge Hurley chose to release Dolores on a personal recognizance bond. He stipulated strict conditions. She must stay 500 feet away from her ex-husband at all times and refrain from any form of contact, including calls, texts, and emails. Emphasizing the gravity of his warning, the judge expressed reluctance to incarcerate an 80-year-old woman with no criminal record, but stressed that this was her final warning. Dolores vowed to comply, dramatically swearing on a stack of Bibles and all that's holy, that she would avoid her ex-husband. The hearing concluded on a lighthearted note, with everyone, including the judge, the public defender, and the other inmates, enjoying the unexpected comedic relief provided by Dolores Shinus.
You are not allowed to call him, text him, email him. You are to stay 500 feet from him at all times. That's where he lives, where he works, anywhere in between. Ma'am, you're getting a second chance on this case. I don't particularly feel like keeping an 80-year-old woman in the jail who has no criminal record. But this is your second warning. Don't go around him again.
I swear to God and all that's holy on a stack of Bibles, I will never go near him, talk to him, call him, or even look at him. What was the
first thing you were going to swear on besides the Bibles?
All that's holy.
What?
I don't remember.
Oh.
What?
All that's holy.
What?
All that's holy. Yeah.
Oh, all that's holy. Yes, sir. I didn't recognize your twang.
Ma'am, have you ever thought of doing a stand-up routine? Have you ever thought about that?
I did. If you pay me good money, sweetheart, I'll be there. I'm really short of funds.
Ma'am, I got to tell you something. You seem like you have a great wit about you.
I do, sir.
Yeah, so...
I mean, sweetheart, that's the only thing I have.
I've been called sweetheart in this courtroom.
Does that mean you're taking me for breakfast?
Let me ask you something, ma'am.
Yes, sir.
How have I done as a judge today? So far, how am I doing?
Not bad, but you could do better.
Can we get a drum roll with this? I got to tell you, you brighten my day, ma'am. All right?
That's what the last guy said, and then he sued me.
However, this next case will shock you, where a woman curses at her judge. In the Miami-Dade Bond Court, Penelope Soto, a young woman charged with drug possession, faced Judge Jorge Rodriguez Chomat. The charges against her included possession of Xanax. The proceedings began with the judge inquiring about Soto's financial status. She admitted she was unemployed, but estimated she made approximately $200 a week. When asked if she owned any significant properties, such as a house, car, or valuable jewelry, Soto hesitated but eventually stated she had some jewelry. The judge also asked if she had consumed any drugs in the last 24 hours, to which Soto responded with an emphatic, "No, absolutely not."
Good morning, Soto. You're being charged with possession of Xanax, B-A-R-S. I don't know what that is. What is that?
Xanax bars. That's how they refer to it.
Xanax bars. All right.
Ms. Soto, you working?
Yes.
How much money are you making a week, approximately?
Approximately about $200 a week.
Okay, and do you own any property of value? A house, a car, a bank account, significant amounts of jewelry?
Yes.
What do you own?
I own a lot of jewelry, all right, as well as
Go ahead.
a car.
Well, how much would you say your jewelry is worth? It's not a joke, you know. We are not in a club now.
Okay, but it's
we are not in a club. Be serious about it.
I'm serious about it. You just made me
I can
laugh.
see you're serious, all right.
You just made me laugh. I apologize.
It's all right. How much is your jewelry worth?
It's worth a lot of money.
Like what?
Like.
Huh?
It's worth
Ma'am?
money.
Have you had any kind of drugs in the last 24 hours?
Actually, no.
Actually, no.
Judge, I'll make it easy for the court, respectfully. I would set the appointment at this time.
No, I'm going to appoint you because you own a lot of substantial amounts of jewelry. You can go and sell your jewelry for a private attorney. What is the standard bond?
It should be.
Ain't going to be no PTS.
Okay, 5,000 on count one, and then the rest should be ROR.
Judge Rodriguez Chomat proceeded to set Soto's bond at $5,000 with the rest of the amount under her own recognizance, ROR. Soto's flippant and dismissive attitude throughout the hearing, including her laughing responses, caught the judge's attention. As Soto was about to leave, she cheerily said, "Bye-bye," which the judge perceived as disrespectful. He called her back, increasing her bond to $10,000 for her inappropriate behavior. Soto, visibly frustrated, flipped the judge off and exclaimed as she walked away. This outburst led to immediate repercussions. Judge Rodriguez Chomat called Soto back again and sentenced her to 30 days in the county jail for contempt of court. Her bail remains set at $5,000. The dramatic escalation of events highlighted the tension in the courtroom and the importance of maintaining decorum.
Count 1 would be 5,000 per hour cost found. Count 2 would be ROR.
The state is requesting ROR on count 2 through 26.
And refer to Division 51. Bye-bye.
Adios.
Come back, ma'am. Come back. Come back. Give me the paper again. Count 1 would be 10,000.
Are you serious?
I am serious. Adios.
You can hear the reaction of others in the court.
Come back again. Come back again. Bring him back again.
What's up?
I believe I heard you saying to...
Yes, I did. I'm not going to the...
I believe you... Did you say... Did you say that?
Yes, sir, I did.
Oh, you did say that?
I'm not
I find you in direct criminal contempt. 30 days in the county jail.
2 days later, Soto returned to the court with a markedly different demeanor. She offered a sincere apology to Judge Rodriguez Chomat, acknowledging her previous behavior as irrational. She expressed regret not only to the court, but also to her family, showing remorse for her actions. The judge accepted her apology and revoked the 30-day jail sentence. Furthermore, Soto's case took a positive turn a year later. Her drug possession charges were dropped after she successfully completed a court-ordered drug rehabilitation program. This resolution marked a significant change from her initial defiant attitude to a more responsible and rehabilitated individual.
My behavior was very irrational, and I apologize not only to the court and you, but to my family.
Don't cry, just don't. Don't cry, I'm not a monster. I know, I make you laugh, but it's all right. Don't cry, I'm not a monster. Go ahead, tell me.
And I normally don't act like that. So...
Let me ask you a third question. Did you use Xanax? Did you take any Xanax Sunday?
Yes, I did.
How many?
2.
2?
A year after that, her drug charges are dropped when she successfully completes a court-ordered drug program.
That's all for this video. We hope you have enjoyed this video a lot. What are your thoughts on these courtroom moments involving women? Let us know in the comment section. Make sure to subscribe to our channel and hit that bell icon for more interesting videos like this. Thank you for watching our video.